Welcome to Easy Learning. Dictation starts in 5, 4, 3, 2, 1, start. We have heard arguments of learned counsel for the parties and perused the record with their valuable assistance. Also, the learned counsel for the petitioner has raised twofold objections before us, firstly, that while cancelling the case, the learned magistrate simply agreed with the opinion of the police and failed to record his own reasons, and secondly, that before passing the impugned order, the petitioner was not given the right of audience. Full stop. This notice was not served upon the petitioner, whereafter, the police statedly made a report under section 173 CRPC to the magistrate that there was no sufficient evidence against the accused as a result of the investigation and requested to cancel the case/crime report. Full stop. The learned magistrate, while agreeing with the report of the police, cancelled the case. Full stop. The learned magistrate is not to act as pawns in the hands of the police and pass mechanical orders without application of their conscious mind to the facts and material placed before it, because the opinion expressed by the police is not binding upon them. Full stop. The learned magistrate must be made to realize that the power to cancel a police case is of wide amplitude, which has the effect of bringing a halt the criminal prosecution, which otherwise would entail a detailed process. Full stop. Such a power, therefore, by its very nature, cannot be designed to be exercised on mere ipse dixit of the police. Full stop. Otherwise, the very purpose for conferring this power on the magistrate on responsible level in supervisory capacity would stand defeated. Full stop.